Okay, great. Hi, everyone. Thanks for attending. My name is David Pittario. I'm a privacy law specialist. I work at a law firm called Venable. Before that, I was in-house at Instacart, Yahoo, and Verizon Media. So great to see you all here today. And I think when I was talking with, okay, so click here. Let's see. Oh, there we go. Okay. I skipped ahead here. When I was talking with Sydney about this, I was saying, hey, it would be helpful for people who are in Europe to understand if you're going to deploy or you're thinking about launching your product or service in the US, what are some things you want to think about from a legal perspective? And so, because the legal landscape in the US is very different, and so than it is here in Europe. And so here I am to kind of hopefully educate you guys in 15 minutes about all of the U.S. legal landscape. And I'll say, if you get bored or tired, do the hand thing we learned yesterday. Anyway, okay, here we go. So so just kind of talk through about, here's an overview, right? And so I want to talk a little bit about trust. Then we have a surge of consumer privacy class action related to chatbots that you should all be aware of. You should also know about the liability for output. There's a lot of cases around that. And then we have what regulators are in place. So we have different things. We have the Federal Trade Commission, and then we have state attorney generals. So each state has its own attorney general, their own ability to bring cases against companies. And so that's important to appreciate. Touch on copyright litigation, and then some closing thoughts. So in 18 minutes here. Okay, so trust. Imagine, and I'm going to go back to my in-house experience. And so when you're an in-house attorney, you just work for the company, and your clients are the internal product managers. And so imagine a project manager comes to you and he says, hey, look, I want to launch a privacy-focused search product, or I want to launch an AI product, and I want it to be international, and your heart stops a little bit like, oh my God, that's so much work, right? And additionally, I want to use user data, and I want to kind of have it maybe in 26 or 30 countries. And you're like, oh my God, like 30 countries, like what am I going to do, right? So you work with them, and you spend a whole year on this search product, and you talk to the engineers, and you're like way in the weeds with the engineers about how the tech stack works. And I don't know how many of you have worked with your engineering team, but you think you know as a lawyer how things work, and then suddenly at the next meeting, things are a little different. And then the next meeting, things change again, right? And so you're trying to draft the privacy notice, and you're trying to explain to people how the data is used. And you come to appreciate, hey, I don't even think that a lot of the people in the company know all the ways data is actually used. Yet you're responsible for kind of laying that out and helping people understand that. And so you go through this whole process, and you finally launch a product, and maybe you have to work with some regulators like the Irish TPC. And they're never going to pat you on the back and say, hey, this is great, go out the door. They're just going to kind of give you a pass, right? And say, okay, you're good to let this out the door. You finally launch your privacy-focused search product. You have a privacy policy that lays out in great detail how the data is used, retention schedule, soup to nuts. Your competitor doesn't have anything at all like that. They're just like, hey, we're private too, and we keep your data private. And you're really, you've really done a good job. And then you launch it, and then along comes the comments from the users. And they say, hey, isn't that the company that had that huge data breach 5 years ago? I wouldn't trust them with my personal data. I wouldn't trust them with anything. And you see hundreds of comments like that. And that's the trust, right? That years ago, or even very recently, something happened in the company's history that you had nothing to do with. And you may have made a huge effort to get things right this time around, and maybe you weren't even at the company at that point. And suddenly you see, look, my product or my service is hobbled by what happened years ago. That trust isn't there, and it's very easy to lose. So that's why I kind of want to start this talk about trust, because a regulatory action, action by a state AG, especially in the US, could be in Europe, can really hobble your future efforts. And so you have to think about, like, when you're trying to justify the spend of getting it right, that's part of the consideration. Is that for years into the future, people can remember where you didn't get it right years ago. And as a result, your future efforts are going to be really damaged. So that's the first piece here. So now, Some more opening thoughts. The U.S., unlike the European Union, is kind of a mosaic of privacy regulations, right? We have a lot of states with privacy laws. As of March 2024, we have California, Colorado, Connecticut, Delaware, Indiana, Iowa, Montana, New Jersey, Oregon, Tennessee, Texas, Utah, and Virginia. We also have sectoral laws in the United States. We have HIPAA, we have Gramm-Leach violation, and so sectoral laws kind of go to a specific area like healthcare or financial services. We also, we have AI bills pending in certain states. Some are dealing with algorithmic bias, and some are dealing with more employment and use of AI in the employment context. Others are just Bill of Rights, consumer protection. The only one I think that's passed is the New York Employment Act. That has to do with AI use in the employment context. But still, not one homogeneous law that kind of covers AI like the EU AI Act. Not one homogeneous law that covers privacy. And you say, Dave, I thought the US was working on that. Well, they were, and our legislature was, but now we have elections. 2024 is coming. We have Trump, Biden, JFK Jr., we have congressional elections. We have all sorts of stuff going on. So the odds of federal level privacy law passing at any time is probably pretty slim. There might be something in the children's privacy context that you would see, but certainly nothing on the scale of what the European Union has been able to accomplish just in the past day or so. So that's something else to keep in mind when you're kind of thinking about that. So this is a great map from the IPP, the International Association of Privacy Professionals. And this kind of gives you a feel for where what states have introduced and have passed privacy regs. A lot to digest here, but you can see in this patchwork, there's a lot of parts of the country that don't have anything, or don't have anything that's explicit on the books. There might be a consumer protection law or something like that that you could apply in a privacy context, but generally we have like California, Oregon, Montana that all have regs. And so that's something to appreciate. Again, this patchwork, not every state is in the same, not every state in the United States is in the same position when it comes to privacy. So that's something to keep in mind when you're launching your products, right? So now let's talk about class action litigation. And so, just so some of you are familiar with this, class action litigation is where one person comes along and you have a firm that will say, we're going to take this one person and they're going to be the class representative for all the people that are similarly situated. And they were harmed in some way, and we're trying to get recovery for all of the people that were harmed in that way by bringing this action against a company for a particular product service issue. And so there's been a ton of class action litigation around chatbots. And the genesis of this, there were two appellate court decisions that were claiming that websites were using chatbots, that they were wiretapping or eavesdropping. And you're saying, well, how does that work? And you're like, well, they were applying this old law from, let me see, I'll jump ahead a little bit here. There's two cases like that, and so you can see some of the boundaries. But there was an old law from 1967, and it was saying it's illegal to covertly eavesdrop or record a telephone conversation. And so, and it's a private right of action. That's something else where any individual lawyer or any individual person could bring this law, this case against the company. And so that's a big issue in the United States. Whether you have a private right of action as an individual, I could bring a case, or whether only an attorney general or a federal law enforcement body can bring an action. And so, just jumping back here, you have two cases where they take these old statutes and they apply them to modern technology. And so there's a lot of questions around this, and it's like, well, gee, we're looking at this and it's saying, are chatbots, are they a party to the communication? Are they just a tool for the website operator? And is it an unlawful interception of a communication? And so they're trying to look at that and figure it out, and that's kind of bouncing around in the courts. But in the interim, a lot of litigation around that. So this is California, and you can see California on the map here. So that's something to be aware of if you're thinking about deploying in California. Appreciate that there's a lot of that activity going on right now, and it's unresolved. So if I was deploying, would I deploy in California? Probably If I was thinking about launching a product or service, I would say, hey, maybe pick another state. So now, there's also just another thing you guys should be aware of, BPC 17941, and there is another reg in California that says that, and it's a transparency reg, right? It's a problem if you have the intent to mislead the other person about artificial identity. So there's something else to keep in mind if you're using a chatbot, but you're not disclosing that you have one. And so that becomes a problem, for sales or for dating apps, that kind of thing. So that's something else to keep in mind. Now, liability for output, and I have 9 minutes. This is good. I'm doing okay with time-wise. Liability for output's interesting. So, a lot of companies, they'll throw up a disclosure. And some of the cases, like there's the one with the airline that I think there's somebody else going to talk about this today, or maybe they talked about it yesterday, is Air Canada. And so, it wasn't AI, yeah, it was just but it was more, that's one kind of, that's there, right? What I'm more, what I'm more interested in is there's a Georgia case, right? And so this one was a person said, hey, can you summarize this case and can you tell us what it's about? And the way it described the case, this person said, oh, they're a party to it, and it defamed them in the sense of it was saying that, look, this person was accused of defrauding and embezzling and all this stuff, just totally hallucinated. And, the person came along and said, this is the actual text from the complaint that they filed. They're like, every single statement that was produced by that system was false, 100% false. Imagine you typing your name and they said, you're an axe murderer, you did X, Y, and Z, and you're like, that is 100% false. So this person, they brought a suit, and that suit is still pending right now. So it's something to think about when you're deploying and when you're kind of looking at your systems and saying, hey, look, there are people actually suing for incorrect information or information that paints them in a false light out there in the United States. So it's something you have to defend against, put up notices, be aware of, right? This is a little more of the complaint. But it went through, that the allegations by the person were false and malicious. And they kind of talk through what a hallucination is. And usually some audiences I talk to, no one knows what a hallucination is, and they're like, what? But you guys all know that, so you can skip past that. Regulators. So we have FTC, Federal Trade Commission, and then we have the state AGs. I kind of mentioned them. So how can you get in trouble with the FTC? So a lot of ways companies get in trouble with the FTC is they put something in their privacy notice or privacy policy that's not accurate. So how does that happen? If I say things like, I eliminate every amount, there's no bias in my service, okay? No bias whatsoever. My service is 100% secure to an end user. We all kind of laugh, but there's some policies and notices out there that say things like that. And there's cases where the FTC has taken action there. And it's the way they treat it is like, hey, you're not being honest with the user. If somebody's actually reading your policy or your notice, and they say, oh look, they're claiming that they're 100% secure. They're claiming that there's no bias. They're claiming, and then something bad happens to me as a consumer, I'm harmed. And so the FTC takes up those kind of cases. The state AGs are a little bit different. They will take up cases, but it's on a state-by-state basis, and they'll say, okay, you've harmed the users in New York State. You've harmed the users in California. And so sometimes they get together and they act as a group to take action against a particular company. Sometimes they work independently. So those are kind of the regulators to watch out for in the United States. Just one other quick thing I want to point out. So how could this how could that affect a European company moving over to US, right? Imagine you have your privacy notice in German, and one of your investors, their son is great at translation, supposedly. And they say to you, hey, look, we're going to deploy in US, have your son translate the German privacy notice into English. And in the privacy notice, my example, which I love a lot, is they say something like, we have, the original German says something like, we make efforts to reduce bias. And then the translation, because the 17-year-old son of the investor doesn't really understand the concepts or anything else, they say, we have no bias. And so you translate that into the English and you publish that policy and you launch in the US. Well, what are the regulators going to say? You know, user comes along and there was something like that that was in the privacy notice. So that's an example. I mean, it's a little contrived, little, you know, kind of, but I've seen that in my private practice where in Europe you have privacy notices that are either 100% incorrect, they're translated incorrectly, they're translated by people that are high school students and do not understand, or college students, and do not have the legal context to understand the legal knowledge of what the terms are. And so you'll have a local language lawyer go through that privacy notice and they'll be like, look, this is all garbage, and flag things. So something to keep in mind as you're going back and forth, or if you're taking a French policy and translating it to English, or if you're going US and then going to Europe, or going to India or China or somewhere else, as you're kind of internationalizing your products and services. There's something else too. FTC is looking at impersonation. I don't have a ton of time, only 4 minutes left. Something to be aware of, but they are looking at chatbots. It's a little weird the way they kind of phrase this here, but they're focusing on a rulemaking around this, and it's something to be aware of and keep an eye on. Let's talk really quickly about algorithmic disgorgement. Another favorite thing. So, you know, gorging yourself, maybe some people went out last night, they ate too much, they went to dinner, that kind of thing. Well, now let's talk about disgorgement, where they say, look, and the example here is Weight Watchers International. And so what these guys did, and it's just an example, but they took a weight loss app that was made for children, but they didn't get parental consent when they collected the data. Consent is crucial, right? And so then they built models using that data. What did the FTC come along and do? They said, look, you have to destroy all the personal information collected where you did not have consent, and additionally, you have to destroy any models or algorithms that use that data. Disgorgement. So something to keep in mind is like, when people say, well, what is your training set lineage? How is your model trained? What consent did you have for the data that was in that model? Well, this is the product. If you don't have that right, and you didn't have the right consents, and you were, for example, here, you're collecting children's data without verified parental consent, there's a risk that you will be made to delete your model. So it's a concern and something to keep in mind as you're working out. Copyright, really fast. Sarah Silverman and a bunch of other artists brought suit against OpenAI. On motion to dismiss, there was kicked out for direct copying, for vicarious copyright infringement. There's other suits like this that you should be aware of. It's still a mixed bag. Still don't know how this is going to come out in the end, but it's something to kind of watch and be aware of, that entities are still bringing, or individuals or groups of artists are bringing these copyright suits against how models are being trained and what the model output is. So that's kind of something to kind of keep in mind here. So here's some quick takeaways in the last minute and 50 seconds. If you're going to deploy in US, you got to check the local laws where you're going to be deploying your service. Only deploy where you understand your legal obligations. I can't count the number of times I've seen clients and they're like, hey, I went to the App Store and I checked every box and I'm in 190 something countries, or I'm all over the world. Do you know anything about the laws? No, just checked all the boxes, okay? A lot of legal work to be done there. So there's something else to think about too, and it's like, well, if I'm gonna deploy something, you know, when you're in-house, you kind of think about this. What state might I deploy in that maybe is not a hotbed of litigation? And if I have an option, I might not deploy in a state like California, but I might deploy in Oklahoma or some other state. And so if you're thinking about deploying in the US and you're only doing a bucket test, or you're only doing something that's small, a proof of concept, you might want to pick a state, or you might want to pick a jurisdiction that maybe doesn't have a ton of copyright litigation or consumer class action litigation. And so you can work with a U.S. attorney to kind of understand that and figure it out, if you have that option. Some people are like, I don't know where, you know, it really depends on your service. If you know where the users are, then you can kind of do that. Two-party consent. So this is another real, some states in the United States, they require both parties to consent to a conversation before you could record it. And some services, they record all of the transactions, all of the user interaction, and keep it somewhere else. Some states only require one-party consent. So if I'm concerned about litigation, I would think, okay, well, and you're not sure about consent, or you're struggling with it, or you're worried about litigation, look at one-party consent state first. Two-party consent, California is a two-party consent state. That's part of why they're having all that litigation. Carefully review the notices, disclosures, consent requirements from end users. Seek indemnities in your agreement. If I'm a service provider and I'm working with a partner in one of these jurisdictions that has a lot of litigation, think about what the agreement's going to look like. Maybe you get some indemnities. Say, look, I don't want to be in the hook. You really want to use my service, but I'm a small company, right? So think about that part of it carefully. Test your chatbot to avoid truth issues, or your service. The Google case, the airline case, all those kind of things. Like when somebody says, "What is your policy about refunds?" or somebody says, "What is your privacy policy?" Do you want your service to generatively pull up a policy? Do you know that it does or doesn't? Have you tested it? I want my service to give the policy that actually is my company's policy. A lot of people don't do that test. And they're like, okay, they put it out there, and that's a real issue. Understand the lineage of your training set, keeping in mind consent and purpose limitations. Core user rights, guys in Europe, you're in a good spot. You get access, you get deletion, you get correction. We're coming on board with that in the United States. So if you have that built into your products and services, you're already halfway there. For my US clients that are going the other way, that are maybe in a state that doesn't have that, and there's less so, that's a hurdle for them, right? Because they're like, how do we support access across our 10 systems, and some of them are legacy and everything else. So for them, it's harder. But here in Europe, you're kind of used to that. You've had to deal with this for 5 years. You're in better shape to bring a product over to US. And then the last thing, this is a fast-moving area. Stay on top of the legal developments, and work with local counsel. When I was in-house, I think I must have worked with like 10 or 15 different firms when we were going international with the product. Don't be shy about that. Get budget that you need. A lot of times people will want you to do a lot of stuff, and they'll say, okay, I want a product manager, and you're like, hey, we want to go international. How many countries? All right, well, what budget is that going to take? And you have to advocate for that budget. Because, if you don't, you're going to be like that guy checking all the boxes, and, well, I don't know what the laws in India are that apply to my product. Well, why are you launching there? So you need to have the budget to hire a local lawyer to actually help you understand what you need to do, so you don't get caught out and you don't lose that trust. Because that is so easy to do, and so many companies fall into that trap. So hopefully 15, 20 minutes, quick overview. If you want to continue the conversation, I'll be around, or shoot me an email. Here's my contact information. And, again, thanks so much. Amazing conference. Love being here, and love the depth of all of the topics. So, and hopefully see you all again next year.